Hi, and welcome to this month's virtual town hall. I'm Dorothy Ripka, a litigation partner with Cordell Cordell. This month, we will be discussing 5 key things guys should remember when facing divorce with 4 of our Cordell Cordell attorneys from all across the country. Cordell Cordell is the world's largest domestic litigation firm of its kind, with 30 years of experience in all facets of family law. Stick around for our Q&A segment where I will have our attorney panel answer live viewer questions. Please be sure to submit your Q&A questions in the chat section. Also, please remember to put your questions to townhalls@cordelllaw.com so we can include your questions in our next segment or in the podcast. We will be answering even more of your questions during our podcast through Cordell Cordell's Men's Divorce Podcast resource. Don't forget, Cordell Cordell is also providing virtual consults during this time to help keep you and yours safe. By way of disclaimer, I must indicate that an attorney-client relationship is not being formed as part of this webinar, but rather, if you would like to have legal advice, please contact one of your local offices to speak with our Cordell Cordell attorneys. Let's meet our Cordell Cordell attorneys. First up, Asa Neff. He is a senior litigation attorney in Alimony, New York. Asa?
Hi, Dorothy. Thanks for having me today. I'm licensed in New York State and practice throughout the state. I've been practicing law now for about 15 years and with Cordell Law, representing men in divorces for the past 9 of those years. Glad to be back on the panel.
Thank you. We're glad to see you. Next up is Stephen Babe. He is a litigation attorney from Des Moines, Iowa.
Hi, Dorothy. And yes, so I've been practicing. I'm in my 3rd year of practice. I've been with Cordell since August of 2018, and it's a great position. I really enjoy representing primarily men in divorce and custody issues, and it's a great firm. And again, thanks for having me on the panel today.
Happy to have you. Thank you for joining us. Next up is Athena Hwang, who is a litigation attorney in San Diego, California.
Good morning. I'm Athena Hwang, and I am licensed in San Diego, California. I've been practicing family law for about 6 years, and I've been with Cordell since 2017. Thank you for having me this morning.
Thank you. And our final participant is Presley Davis, who's a litigation attorney in Jacksonville, Florida.
Hi, good morning, Dorothy. I have been practicing in the state of Florida for 3 years now, and I've been with Cordell since October of 2020. And thank you for having me here today, Dorothy.
We're glad to have you. And I will be also participating in the conversation today. As I said at the outset, I'm Dorothy Ripka, a litigation partner with Cordell Cordell. I've been practicing family law now almost 21 years, and I'm licensed in 5 states, working on my 6th state here in Colorado, and with Cordell 18 years. So we're going to get started right after a quick commercial break. We're going to get into it. So come right back.
For many men, divorce brings a bewildering sense of loss. After years of commitment and responsibility, you find yourself alone, like you're the only person in the world. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell Cordell, a partner men can count on.
All right, let's get started with those 5 things guys should consider when facing divorce. First up, we're going to talk with Presley Davis about choosing to stay or go, and whether or not you should move out of the marital residence.
All right, Dorothy. So there are very limited circumstances when we would recommend staying or moving out of the home. For the most part, there are several benefits to remaining in the marital home. The first benefit that you have is a financial reason. It's much cheaper to live under the same roof and share your customary expenses with your spouses. Additionally, you get more time with your children if children are involved. It's easier to see your children without the added litigation when you're both living under the same roof and performing those customary routines that you do have with your children. And lastly, there's a support issue. If you are both living under the same roof, you're going to be sharing those expenses, and you're going to be reducing your exposure for temporary alimony if one of the spouses is going to be requiring that. So that's just something that you need to consider overall when you're debating whether or not to stay in the home or move out of the home. But we definitely recommend staying in the home as long as possible.
Now, would you say this is something you should be discussing with the attorney, though, about your specific circumstances, or does that general rule apply for everyone across the board?
Everything is absolutely on a case-by-case basis, but definitely speak with your attorney if this is something that you are considering. If you're having issues, talk to your attorney. They can help you strategize on what you need to do moving forward in your case to make sure that you're doing what's most beneficial for you.
And is this something that you should be, should you be recording kind of the pros and cons and the expenses being expended while living together in the home? Is this something that will be relevant later on in your case?
Absolutely, this is going to be something that's going to be relevant in your case. Record your expenses, know how much you're spending on your utilities in case you need to move out. So keep a detailed ledger of these items that you're spending your money on, especially if you have to move out and get a separate residence. It's always important to make sure that you're tracking those expenses.
Now, if you are living together in the home still, should you be also tracking your parenting time?
Absolutely. It's important to know how much time you're spending with your child, whether you're in the home together or outside of the home. It's going to come more into play if you're not living together, but you definitely want to keep account of who's getting that time with the children.
Okay, very good tip. Next up is Asa Neff to tell us kind of about how to not escalate issues and keeping our cool.
Yeah, thanks, Dorothy. It's an interesting topic. Obviously, you're going through a divorce. You're living with somebody who you're probably not getting along with the best, and arguments are going to happen. If they didn't happen, you probably wouldn't be going through this to begin with. But the best advice we can give is to make sure they don't get out of hand. It doesn't take a lot for someone to claim they're being harassed, to claim that they've got to try to get you out of the house. And if they do that, it creates a lot of problems. Presley was talking just a moment ago about all the reasons you should stay in the house. She was talking about that voluntarily, but of course, if arguments escalate and they do get out of hand, then you might not be given that choice. There might be orders of protection in place and you might be forced out of the house. So you're going to be facing all of those things that we're talking about trying to avoid, the financial consequences of support and the inability to see your children whenever you want, all because things got out of hand. So it's really important to try to de-escalate situations whenever possible. Remove yourself from the situation whenever possible and just don't let things get out of hand. Besides just being in those altercations in the house, fights in the house, there's also the written communication, text messages, emails you might be sending. And we like to remind our clients that those can come in as evidence that can be used later in a case, evidence that can be used to determine what your time with your children is going to look like, whether you're going to be able to be involved in the important decisions in your children's lives. And judges don't have a sense of humor, we like to say. They don't read sarcasm. They're going to look at two people who just can't get along and make a decision based in part on that. Now, there's a lot of things your attorneys can do to mitigate that, but the best thing you can do is not let it happen to begin with. So, while you're going through this very, very, very difficult time in your life, it's important to just take a step back, take a breath, and de-escalate the situation, whatever it might be.
And you were mentioning communications. Do you have any advice for our clients or the people watching out here as to how you can work that communication, any communication tools they can utilize in this process? And should they be recording communication, keeping it in some fashion?
Well, yes, absolutely. First of all, if you can't speak to each other in a civil manner, then you should try to keep it to writing. Otherwise, you're going to have a lot of he said, she said. So texts are okay. Just make sure that you are showing restraint. Emails are great. Just make sure you're being respectful. What I tell people is write every email as though it's going to be read by a judge, because it might be. And when you keep that in mind before you send it, before you hit that send button, then you'll end up you'll end up much better in the end.
And with respect to the communication, have you seen any good examples of how to handle it if you do make a mistake in communicating? What's the best way to sort of mea culpa for that to rehabilitate your credibility both with your spouse and the court?
You know, the best advice is just own up to it and send an apology, because that'll come in also. You know, people have these emotions in the heat of the moment, and everybody's human and everybody gets that. But if you talk to your attorney, you can try to back those things out and say, you know, we said some things, got out of hand. I was wrong. It won't happen again. And then just really try to mitigate that damage as much as possible. But it is good advice. Own up when you've made a mistake, apologize when it's appropriate. And, you know, that'll be shown as well. So, you know, take the high road, admit if you've made a mistake, and, you know, your attorney will work with you, help you mitigate any damage that might have been done.
One of the tools I've seen, Asa, is there are programs out there like Our Family Wizard and other types of parenting communication tools that actually have filters that assist you with your tone. So something to think about too is if you really feel like you need help with that and you don't want to have your attorney read every email for you, you know, that's a good tip. And then I personally use in my own life and practice the philosophy of if I'm not sure if I should send it, I wait 24 hours. And if it still seems like a great idea to send, then I send it. And a lot of times I've edited myself down to a proper tone by then. So
I've had a few clients who have utilized Our Family Wizard. It's a great tool, not only for communication, but for calendars as well. So that really will cut down on the cost of your attorney having to edit every correspondence with you. But it is a good idea, and there's other good practices that can help as well. But taking a deep breath before you hit that send button is great advice. Sleeping on it, waiting until the next day, take a fresh look at it, also great advice.
what happens if this escalation is not by written communication? What if it's in person? What kind of advice do you have for the guys out there of how to de-escalate or keep things cooler if it's an in-person disagreement?
You know, if things are getting out of hand, I tell people to just remove yourself from the situation. You know, we don't want to have anything dangerous occurring, and we don't want it to get it to a he said, she said. So whenever possible, if things are starting to get out of hand, to remove yourself. And unfortunately, there's things you might have to do to protect yourself. So if things are really starting to escalate, and this is very state specific, you can, in some situations, record what's going on. In New York, as long as you're a party to a communication, you can record it. So if you have your cell phone in your pocket, you can hit record and start recording video or audio. And that I've unfortunately had experiences that's really saved people from being accused of doing things that they absolutely didn't do. So when arguments do start getting out of hand, that might be what you have to do in order to protect yourself.
Yeah, that's good advice. And I would say at a minimum, recording it in a present recollection of what happened, emailing it to yourself or emailing it to a friend. You know, a lot of times guys are embarrassed to say they were fearful in a situation or that they feel that they may have been abused in a situation. And so it can sometimes be hard to talk about or to document. So it's good advice to remember. It's really key to try to prevent the escalation from happening and then to remove yourself and document it. That's good advice. I think, are we moving along then to Athena next up with don't leave anything out, which is a perfect segue for providing clear records to your attorneys to help your attorney best document and represent you. Athena?
Thank you, Dorothy. So what many clients don't realize is, you know, what might be a small or insignificant fact to a client can be something so significant that it completely changes the outcome or the course of action for a case. And for example, you know, if you have a domestic violence restraining order being litigated in family court and there's a temporary order in effect against you, you naturally want to resolve the case as quickly as possible to terminate any temporary orders that may be in place. However, if there's a domestic violence restraining order that's being litigated concurrently with a criminal restraining order, it's not unusual to delay the restraining order proceeding in family court until the criminal matter is resolved. And one of the reasons for that, a big reason, is to prevent self-incrimination from testimonies that are made in family court to then be used against you in your criminal proceedings. So there's a lot of times that's not also criminal, but other civil proceedings or bankruptcy proceedings or the legal matters that may affect your family law case. And that's why it's important to inform your attorney of matters, even if it may not directly relate to your family law case. It's also important to be transparent with your attorney because you don't want your attorney to be blindsided in court, especially with information that may not necessarily be favorable to our clients. If your attorney has no idea of certain information, your attorney most likely than not will not be able to provide a reasonable explanation to the court because they didn't have that opportunity to speak with the client and discuss it prior to the hearing. So it's always better to inform your attorney of quote unquote the bad facts, even if you're embarrassed or even if you feel that you want to leave that specific detail out because it may hurt your case. But it's important to be completely transparent, good or bad facts, so that you and your attorney can have that opportunity to discuss the matter and proactively strategize the best way to mitigate that fact. I've had many clients tell me, hey, I didn't tell you because I'm embarrassed, or hey, I didn't think that was important. But I like to remind our clients that we as attorneys, we're not here to judge you. We're here to advocate for you. But that's difficult for attorneys if we're not aware of all of the facts that may be relevant to your case. And that's why it's extremely important to tell your attorney, everything that revolves around your situation or your case, whether it's good or bad. That's
really good advice, Athena. I think one of the things I've noted in doing this for so long is the best offense the best defense is often the best offense is often a good defense. Sorry. So basically, if you know a bad fact and you can create a scenario where you're able to prevent it from having the wow factor, it can make a big difference for the court if you get your bad fact out first and put context to it. And that's I think it's actually on my profile on the website. I think it's probably one of the most important things I tell clients is, tell me anything and everything, because you have to have really that trust factor built up, because chances are it's not even the worst thing I've heard today, let alone, anything I'm going to judge you for or be critical of you for. The best thing we can do to help you is to know the information. And sometimes that, it's hard. It's a hard conversation, but 9 times out of 10, it's really, beneficial for you as the client to get that information out to us. And sometimes same thing with bad facts about opposing parties. Sometimes it feels embarrassing. They don't want to, sound like they're being punitive, but oftentimes that information really can lead to being a key to your case, or us being able to prepare to defend another element of the case. So that's some good advice.
Yeah, you made a good point too about, bringing out bad facts first before the opposing side can bring that out. And, the purpose of that in some situations would be so that it doesn't seem or appear to the court that you're hiding that, specific information. And instead you're providing it up front first and explaining, the details around that situation or the circumstances around that situation.
Right. Yeah. And I think another key component with documenting is making sure that you, do it in a really coherent way that you can find the information. And so your attorney can effectively get through the information, because one of the things I'll have clients come in and they've got journals and books and emails and different mediums that they've been recording communications and oftentimes, while it's very helpful, it can be very cost prohibitive for a client. So while you're considering how to document and what to document, consider how you document it as well, so that we can put it into a really cohesive package to benefit you to the court, because we are so oftentimes limited in our ability to present evidence, whether it be in form, as we've all been living with doing Zoom and WebEx hearings, or limited in time. So the better organized we are as teammates, ourselves and our clients, the more effective our representation will be as well. So.
And I think it's very important to point out that that's a discussion that every client should be having with their attorney, because every attorney is different. They have different preferences as to how they practice law. And so one method may work for another attorney while it doesn't for someone else. And so that's definitely something that should be discussed between the client and the attorney, so that both are on the same page and both can effectively present the best case possible.
I agree. Thank you. Very good information, Athena. Thank you. All right, we're going to move on to Stephen, who's going to talk to us about putting the kids first and not neglecting that important parent relationship while you're dealing with such a stressful situation as going through a divorce.
That's right. So I know a lot of people think, well, I have so many other things going on. I have work. I'm going through this separation, considering the future and other things. But the biggest thing is either property division and custody. I'd say custody is always the main one. And focusing on your kids is something that I'm not saying people neglect. It's just that I'm not sure sometimes that they know how to prioritize. I say they as in clients, potential clients, prioritize things that are so important that a court would look at. So I know in Iowa, where I practice, we look specifically at how is each parent involved in the physical, mental, and social welfare of the kids. And so you just break those down into categories. We talk about the physical welfare of the kids. How are they doing physically with respect to their actual physical health? Their, how their eyes doing? How's, the things with their dentist, things like that. I mean, you got to schedule appointments, take them to appointments, talk with the other parent about how was the appointment. And so there's a lot of activities involved in that. And are you neglecting to be involved in every single one of those activities? So it is important for parents to think, what do I need to do to make sure that I'm involved in my kids' physical health? Again, emotional health, we talk about that, mental, emotional kind of intertwined, but the kids are going through a hard time too. Kids may have already been having issues either at school or, emotionally on their own. And so monitoring your kids, how are they doing? You can see this. So are you communicating with the other parent, letting them know if you're having concerns? If you're not, then that's a breakdown that is not helpful. The court wants to see the parties getting along well enough to co-parent. And so obviously that's a factor that an attorney will focus highly on with you and in coordination with you. And so don't fall into the trap of thinking, my kids don't need counseling or therapy. If they need it, you can let them speak with a counselor or therapist, and the counselor will make that determination. I get it, but there's a lot of parents, I shouldn't say a lot, but there are some that think that it could be shame on the family if the child needs some sort of medication to help them with their anxiety or levels of depression. But there's no shame in it, and the court would never find shame in it. Matter of fact, they'd see it as being an issue if you are not prioritizing your kids' mental or emotional health. And then I guess the last topic on this specific item is considering your kids' social welfare. We're talking about keeping them involved in activities and how are they doing in school. And there's just so many little things that go into that analysis as well. Are you making sure they're at school on time? Are you making sure you're not just calling them in sick when they say their stomach is hurting a little bit? Are you coordinating with the other parent on all of their extracurriculars? Are you able to agree on what activities they can partake in? I think that most parents should probably strive to keep their kids in the same activities that they've always been in, or encouraging them to remain in those activities. And so there's just so many things that parents may not think detailed about while they're going through this court process, but that's what an attorney's for. We talk about all the little things that you should be doing in your case. And again, documenting everything and making sure that you're acting like a co-parent with the other person. So it's just, again, it sounds simple, but it's very nuanced. And it does sometimes require, and oftentimes require, an attorney that gives you those expectations and makes you feel like you're accountable and that you're doing what you can do as a parent to make your case as good as it can be, so that, again, you are increasing the chance or opportunity for you to be successful at the end of your case and reaching the goals that you hope to reach. So again, it's a great conversation, and it's just something that I'm not sure if some parents really get into the details and nitty gritty and prioritize it as much as a court would like them to do.
One of the things you said that I think is really important is thinking about, a lot of times our clients want to say, well, mom's failing to do this or dad's failing to do this. It's really important. I use a phrase called put your foot in the door. I always say you can't expect someone to open the door for you. You have to put your foot in there and open it. You have to keep pushing to find out the information, to show up at the appointments, to be part of your kids' lives. And when you say the word neglect, family law attorneys start thinking a different term. I mean, we're saying not prioritizing it, right? We want to prioritize our kids and recognize that, going through divorce can be as stressful for a child as having a parent die. I mean, it is literally that level of stress for some children. And so getting them the help they need, being a constant for them, giving them that continuity in extracurriculars and school, and you being sort of the rock for them, even if, maybe you crumble after they go to sleep at night, is really something parents have to be reminded of, because it is so stressful for everyone involved. And so this is kind of a good segue back, though, as far as saying, this is why you have to make sure you're documenting. If you're participating in the soccer team and you go to the games, or you're coaching, or you're at the braces appointment, whatever it might be, this is an opportunity for you to show, rather than the flaws of the other parent. Well, I wasn't there, she didn't tell me about it. The better answer is, I was there because I cared enough to find out the information on my own. And I got signed up for everything. I'm a responsible parent. I'm a good co-parent. And those are the things, as far as your kids go, I would encourage, those of you listening to think about this in a proactive call to action. Think about ways you can do things to improve your child's life going through the divorce. And ways you can do that is by trying to, as Stephen said, focusing on all facets of their health, because those factors, while they're a little different in Iowa than some other states, it's all about what's in their best interests, and thinking about how you can best serve your children's best interests going through what is such a stressful time for adults and kids. So thank you, Stephen. That's very helpful. Our next topic actually segues pretty well here, and it's about going all in and being fully invested in your case, and remembering your attorney can't do a great job for you unless you're an active participant. And I think Athena and Presley, you guys are going to tag team on this topic.
Yes, Dorothy, and I'll go first. A common misunderstanding or mindset that clients may have after they retain counsel is, okay, now, I don't have to be so involved in my case. I can take a step back and let my attorney take control over my case. Being hands-off or non-responsive with your attorney will be severely detrimental to your case and can affect your attorney's ability to provide adequate representation to the client. Representation, like I tell my clients, is a two-way street that requires trust and communication between the attorney and the client. The role of an attorney is to advocate on behalf of the client, to advise you appropriately of the law and give you guidance on your case. What we can't do as attorneys is make decisions that substantively affect your case without your consent or approval. And so that's where a client's active participation is important, because while the attorneys can make suggestions, the ultimate decision is at the client's discretion. With that being said, if a client does not participate or does not communicate with their attorney, it can be difficult and maybe impossible to move the case closer to resolution. And to further elaborate on moving the case closer to resolution, each state has rules and laws in place that require parties to meet certain deadlines to ensure that a case continues to move toward resolution rather than staying in limbo. And if you don't actively participate in your case, this can ultimately negatively impact your case. And in some cases, the court can decide to proceed without your participation or even dismiss your case entirely.
And before we move on to Presley, I think a very important point was made there. Sometimes as attorneys, we can't even continue representation if a client is not participating because there are requirements on us to have client permission and consent to do certain things. So I know sometimes clients feel like it's money saving to not communicate that often, or sometimes they feel like it's so stressful, they just don't open the envelopes for a couple of weeks. And the best thing, that I think that you said more than anything is that this is not an effective team without both people having buy-in and working together towards that, towards that common goal, which is obviously unique to each client.
To elaborate on that, you had mentioned that sometimes clients are a little more hands-off or non-communicative because they want to save in fees or costs, but essentially, it actually has the opposite outcome because we as your attorneys are constantly following up on, our communication. We're calling you, we're emailing you until we get the response that we need. And the more we contact you, the more you're getting billed. So, the sooner you contact us and communicate with us, the less we have to reach out to you.
Great.
I think that's a good segue to the points that I'm going to be making in this segment that, if you are a self-represented litigant, you absolutely have to go all in. I know in the state of Florida, if you are a pro se litigant or a person without an attorney, you're going to be held to the same standard as an attorney in the state of Florida. You're going to have to know your court deadlines, the rules, the procedures, and that can be incredibly overwhelming if you don't know those things. So that's why it's very important to have an attorney on your side who's going to advocate for you, who's going to know those rules, because those aren't something that just come naturally. Those are learned and they take a lot of time to understand. So as a self-represented litigant, you absolutely have to go all in, and that's going to take a lot of time, a lot of effort, and it's stressful. So with that being said, we always want to err on the side of caution and tell you that sometimes it's okay to have somebody there on your side who wants to help you, which is why we always think that having an attorney is in your best interest.
All right, thank you. Hopefully those 5 points were helpful for you guys, and we're going to move into the live question round now. So we're going to try to get to the questions. We've had quite a few submitted today while we've been talking, and then if we can get to all of those, we will. So first up, I think, Asa, the first question is actually a New York question. Someone says later, so I'm going to throw that one to you, which is, if your spouse has moved into an apartment, does the cost of this apartment constitute a dissipation of marital assets in New York?
Well, that's a difficult question to answer. In New York, if the date we look at when dividing assets is the date of filing of an action for divorce. So whatever's in any accounts at that point is what we look at before doing a distribution. Somebody gets an apartment to live in, it's not a dissipation of marital assets necessarily. If it's an extravagant apartment, one that is far more than your prior residence, then certainly that's an argument you can make for something other than an equal distribution down the road. If it's being furnished out of marital funds, and it's again an extravagance, then you can seek a credit. But no, it's not necessarily something that would be considered a dissipation of marital assets. A dissipation is oftentimes when somebody is going on a vacation with a paramour, for example, taking trips like that. That's got nothing to do with the marriage itself. And that would be a dissipation, and it would, you'd ought to be able to get those funds back in. But apartment itself wouldn't necessarily fall into that category.
Thank you. All right, I'm going to move. Let's have Presley, you do the next one, which is if child support and alimony are decided upon divorce, if you get a raise or a position that pays more, is it okay for them to petition to get a higher amount of support from you because now you're earning more money?
You know, that's always a twofold question there, Dorothy, because you have to look at need versus ability to pay, but you also have to look at whether or not there's been a substantial change in circumstances from the time that that final judgment was entered. I know in the state of Florida, that's an incredibly high burden to have to meet. So it just really depends on the specific facts and circumstance for each individual.
And to echo that, a lot of states really base spousal support or alimony or maintenance, depending what you call it in your state, they base it upon standard of living during the marriage. So most likely an increase in alimony would be very difficult. On the other hand, child support is fluid, much more fluid. There's an expectation that there will be changes to child support throughout the emancipation period prior to emancipation. So I think the answer, as Presley started by saying, is it's kind of a twofold answer. Alimony, probably not, unless there's some really radical change based upon what's happening. In child support, probably, because it's an ongoing obligation to your child based upon what your child's standard of living would be had you stayed married. So yeah, and it is very state and fact specific. Each state has their own spousal support or alimony statute, which is not universal at all. So that one is definitely you may need to consult with someone to get your very specific facts discussed to get a little bit better idea.
Absolutely. I definitely see it more with child support in Florida than we do with alimony.
Makes sense. Okay, so next one I'll throw to you, Stephen. It says, my kids are 18, 21, and 22, so custody and child support is less of an issue. How do I best limit financial harm, liability, or exposure I think they say the process. I think they mean the whole divorce process, since it's really not custody or child supported issue.
I mean, that's an interesting question. I suppose you could think, well, is there any statute in your state that could require you to continue to pay for your child's post-secondary education? In that respect, you'd want to look at statute and case law and see what arguments you may have to protect yourself. An attorney can help you do that. I know in Iowa, we do have a statute that does allow for that to happen. There's also a lot of case law that can help to perhaps mitigate the amount that you may be required to pay. So that's one question. Then outside of that, I guess it seems like you're strictly discussing property division. And there again, it's if you're going to move out early, we've discussed this, you're going to move out of the house early, what expenses are you going to have? Obviously, you're going to have your own. You're basically losing your roommate that was helping to pay for half those expenses. So that's an issue. Outside of that, financial harm, liability, exposure in the process, it's again, working with the financial advisor if you need to make smart financial choices. Some people may not need to do that. However, if you think that you may have financial harm, I would assume that you may have some interest in needing to protect yourself. Again, you may need to get in some sort of insurance policy for one sort of insurance or the other to make sure that you're protecting yourself if necessary. Again, I guess one other great point would be determining what your payable on deaths and other beneficiaries may be now while your case is pending prior to the divorce. And then again, immediately after you're divorced, if you were to pass away and you have payable on deaths or beneficiaries on outside policies that would give all of those things to your recent ex-spouse, then that would be something that you may regret. So those are all things you'd want to consider. Attorneys mention those things to their clients quite often. And so again, just working with an attorney is just something that I always advise people to do.
Yeah, I think one of the key things I always tell clients when they're coming in sort of at the beginning is having a financial handle on the global picture is really the key. Knowing what you have, knowing how that, as Stephen mentioned, how that would pass in the event of a divorce or a death, and making sure that you are understanding of all those components from a financial perspective. That I think is the big hurdle people have, is they haven't taken the time to really fill out their finances and get the whole picture. So I think the best way to get in front of that, the questions from David here, the question that I would say the best way to get in front of that is to really make sure you have accumulated all of the information that's relevant to that analysis. And then, you can work with your attorney in figuring out the best way to divide the assets and potentially allocate for future division. So thank you. All right. Let's see, Athena, can you talk a little bit about separation? And it says making a post-nuptial agreement and how that may work, whether or not you should do that versus going through divorce, and impacts post-nuptials can have.
Sure, Dorothy. So it's interesting because if the parties are already separated, I'm not sure that a post-nuptial agreement would be the best course of action. Especially if the parties are not on good terms and are not amicable. So I'm not sure that, having a post-nuptial agreement would be efficient in this situation if the parties are already separated. And so with that being said, divorce or mediation might be more appropriate.
Okay. Yeah, and I think post-nuptial agreements obviously require agreement and consent. So if you're in like you said, a more hostile or high conflict circumstance, you may not be in the best position to start making agreements at that point. But it is certainly, again, an option you can consider, but good points. Asa, I'll throw this one back to you. How do you get a judge to rule on the law and not procedure when procedure doesn't apply to your case? The example is procedure in a modification is change of circumstances, but the only circumstance that occurred was there was a default judgment. Looks like the question is, how can you go back and ask the court to modify something that was entered by default?
Well, that's an interesting question. You rely on the law, and if the judge is not following the law, then you appeal. It's why we have an appeals process. I know at Cordell, we have an entire team that's devoted strictly to appeals because judges make mistakes. They make mistakes more frequently than we like to admit. And yeah, sometimes you're stuck with it. In New York, courts have a lot of discretion with issues such as custody, but there's always a higher court. So you're not stuck with a ruling, and attorneys can take it to a higher power, and that's in New York State, the appellate division. And then even if they make a mistake, then you can take it to a higher court, the New York State Court of Appeals. So if the judge isn't ruling correctly, there's still a remedy available to you. It's involved, and it takes a team of attorneys, but we get that done. So if you feel that judge has entered a ruling against you and it's not the appropriate ruling, then there are steps that we can take to try to fix that.
Excellent. So I'll take the next question since I've been putting you all on the hot seat here. The next question was, can you speak to earning potential? My wife has a great education, but has been a stay-at-home mom. How does alimony work with potential earnings? So again, having practiced in a lot of states, I can tell you this is fairly universal throughout the majority of the states here, which is someone's income can be what's called imputed to them. Imputation of income means that an income that you don't actually earn is credited on your side of the ledger because you have the capability of earning that income. What is different in some places is whether or not that requires expert testimony in the form of vocational rehabilitation expert, or whether or not that's something that can be testified to by the parties. Most of the time it's going to be via expert witness testimony. And I can tell you, in having handled a lot of alimony cases or maintenance cases with a vocational expert, they are often the make and break person in my support case. And they are very valuable. So if you're in a circumstance where someone has a great education, but they've been out of the job market for a bit, this person can actually analyze their earning potential, map that against open job positions or recertification or re-education requirements, and can help you figure out what they could be earning in the marketplace, which can be very helpful, as Presley mentioned earlier, because in most states, need is part of the analysis. So if they can earn enough money potentially to satisfy their own expenses, that you may really decrease or potentially eliminate a spousal support award. So definitely recommend that's something you're going to be needing to speak to, your attorney about, getting a vocational rehabilitation expert involved in your case. Okay, let's see. I've got a couple more here. We keep getting questions. Let's see, who's up? Presley. So it says, can you speak to infidelity in both scenarios? How extensively does it need to be proven, from suspected to having documentation from a private investigator?
Well, I know in the state of Florida, we are a no-fault state. So what that means is the judge isn't going to look at whether or not one spouse cheated or not. However, we will look at infidelity if there is a claim of marital waste and whether or not one spouse was spending money on an affair or on a paramour, taking lavish trips, staying at hotels and things like that. If it's something that you just want to pursue on a personal level, that's your choice, but that's not something that we necessarily look into.
Yeah, and I echo that on the property side. I will say on the custody side, I occasionally find infidelity to be relevant in an analysis of parenting, because if a parent is making choices to escape parental duties and go on trips or go spend time with this significant other versus spending time parenting, and then they want to turn that around and say they'd like equal time or significantly more time than the other parent. I have seen that used, but it does, as Presley pointed out, in my experience, have a pretty limited role overall in most states, because most states have gone to no fault. So infidelity tends to have a less relevant piece there. Okay, we'll go to you, Stephen, for the next one. Let's see, it is one-time instance 2 years ago. I grabbed my wife's arm to grab her phone. I was not arrested or charged, but she reported it. What can I do to show the court something like this will never happen again?
Well, it's a good question. I think oftentimes in a scenario like that, the thing that we would point out to the judge or try to hint on with the judge is, has it happened again? And showing your tone to the judge, again, because we're probably in a court setting if you're worried about it. And so the court understanding your tone, whether there was regret, whether it was an isolated incident, and then again, what is the other party going to say to the judge? And does she have any fear, any lingering fear from that one event? Is she going to say that there's been other times? I mean, how deep or systemic would this be in her mind? So it's a complex question. I'm sorry, I can't give you a great answer, but it's one that, again, you just want to speak with your attorney and actually go over the facts and determine if in your mind there's any other instances that she may ever point out were things that she felt afraid of you on. And so again, highlighting those, trying to see what those events were, what happened during those events, things like that.
I would recommend, in addition to what Stephen said, really the counseling, making sure you've gone through some form of domestic violence counseling, just to make sure it's ruled out that you're not considered to be at risk as a repeated offender. Whether or not you consider this domestic violence or the court does really isn't relevant. It's a way for you to diffuse that bomb. Also, I think you really have to prepare your testimony, how you present yourself on the stand, the kind of words you use, the kinds of demeanor you have, because that is something that I think is oftentimes missed in preparation with attorneys. How you look and portray yourself, the judge will receive so much of that. I think the analysis is 90% of communication is nonverbal. So how you look with your face and your presentation is so key. And so that would be part of it. And then I think just getting the counseling is the other piece, just to show whatever happened isn't going to happen again, having a professional support, that is really helpful for you. Okay. Let's see here. The next one we have is, how do you handle situations where you already recognize there's been poor verbal communication, but as you go through the custody process, you see it's not just the spouse and yourself, but the spouse and others. So for example, found in the child's medical records, a finding of a description about dad having substance abuse problems, even though he doesn't have a substance abuse problem. So I think the question is, how do you attack someone that's been a poor communicator or someone that has been untruthful during the process? Asa, you spoke a little bit about some of this stuff too with escalation. Could you answer that?
I would just say by doing whatever you have to do to prove that they're wrong. If they're providing misinformation, like saying that somebody's had a drug problem, then prove that it's wrong, and that really sheds a light on where the problem is, and that can really do a lot to mitigate those kinds of issues. And if you have to, and if it's just not getting better, you can consider counseling. If you share children together and that's going to continue beyond the divorce, and you're having a hard time communicating, co-parent counseling can really do a lot to help people find a way to communicate with each other, really put their differences aside and focus on what's in the best interest of the children. As this process goes on, even during litigation, I would recommend it when they're continuing to have that kind of issue. I think it's an invaluable tool. It's not always successful, but it can be. And it's worth taking a shot at it. So I think counseling would be really a great proposal for somebody who's having those struggles.
And I think a really good point that you said about showing through documentation that someone's been untruthful, especially to third parties, is important, because those of us on this panel know that the court really makes huge determinations about credibility when you sit in that witness chair. And the things that you say, whether it be in the witness chair or the documents that come in that you previously have said to doctors and to teachers and things like that, they set the record and the tone for what we can expect you to be like as a parent. So while it's not so much the got you moment in court, as Asa pointed out, it's really about what happens in those years after court and how you can become a better parent to your child. And so if, it's kind of it's a good two-prong approach that Asa has suggested here with the co-parenting counseling as well. I'll throw the next one to Athena. Athena, there's this person says he has an expected dramatic reduction in income due to job change and then also retirement. Will the alimony payments be based on a percentage? And once retired, how does Social Security sort of factor into all of that?
That's a good question, Dorothy. So in California, essentially, income from any sources can be considered for purposes of calculating spousal support or alimony maintenance, whatever your state calls it. And so when you are retired, if you're going to receive retirement pay, that's going to be included for purposes of calculating spousal support. Similarly, Social Security benefits that are being paid out to you, that would be considered as income for purposes of calculating spousal support. If you're concerned that your income is going to be decreased drastically, it is important to speak with an attorney about possibly filing a motion to modify spousal support or possibly even terminating spousal support, depending on the circumstances of your case.
Yeah, and I would urge you to think about, I tell clients, if you have an event coming up that is a date certain, you're losing your job on this day or you're retiring on this day, it's really important to really be proactive and get in to see the attorney before that day, because oftentimes the court cannot give you any relief from prior to filing of the motion. So it's really important you're being proactive with those deadlines if it's something you know and anticipate coming up. So very helpful. The next one I will throw back to you, Asa. He says, my spouse moved out and left the kids behind. How would this help or hurt my case?
Well, it's going to really answer a major question about custody right off the bat. If your spouse moved out and left you with the kids, they're already creating a presumption that you're the responsible parent, that you're the primary parent, because they've answered that question. It's the exact opposite of what we talked about early on about not moving out. If your spouse wants to move out, no problem. They can go, just can't leave the kids. You've got a lot of remedies available to you immediately. And this, of course, varies state by state, but in New York, you'd be able to go to the family court, ask for an immediate order of custody, immediate order of child support. You could also go and file your divorce and get automatic orders put into place. And there's a lot that you can do that really gives you the upper hand and the presumption about custody, first of all, and then support. And it really helps your case throughout. So if your spouse moves out, I'm sorry about all of that. And you're going to go through all of that. It's very difficult, but it really puts you in a very strong position when it comes to moving forward with a divorce or just dealing with the custody issues.
And if they've moved out, and as you said, you've already sought sort of some judicial intervention by going to court, that can prevent them from coming back, right? Willy-nilly. They can't just come back in the house anytime.
You really would have to, because they can come back right away. If you're married and somebody leaves and then they just decide to come back, you don't have a real remedy there. But if you're asking the court for what we would call exclusive use and occupancy of the marital residence because somebody else has abandoned it, if you've asked them for primary custody, then it would prevent them from being able to come back in right away. So if that's a concern that they've left and then they're just going to decide to show up, yes, there are steps that we can take to prevent them from just doing that. They can't come in and out of the children's lives that way, and the court would help you prevent them from happening.
Thank you. And as a follow-up, Asa, you mentioned about the appellate court. There was a question, when you do an appeal, if there is an issue, can you actually get attorney's fees awarded or reimbursed in the event that you go through the appellate process?
That's a very, very case-specific issue, whether or not attorney fees would be available after an appeal. I'm afraid I'd have a very difficult time answering that. In some cases, absolutely. You can get attorney fees after an appeal if you're successful. But in a lot of cases, they wouldn't be available, which what does make it cost prohibitive.
Well, I think that the key thing to think about is if the judge makes an error, you aren't getting fees from the judge. And just because your wife got a great ruling at trial, that doesn't mean she's necessarily responsible for your attorney's fees. And that's kind of the way I generally look at it is, the fees on appeal are, as Asa said, pretty rare unless there's some action by the opposing party versus the judge making what we find out is a poor ruling.
Yeah, I agree with that entirely.
Yeah. So let's, Athena, I'll go to this one for you. If we have a 401k that needs to be split, would you recommend that they split it on a percentage or on a dollar amount? And why would that be a very hard question to answer?
That's a good question. That is case specific, and that's something that, the client needs to discuss with the attorney, because if it's your 401k, you might not necessarily want it to be on a percentage basis, especially if you have cost of living adjustments, because as you get cost of living adjustments, the amount that's getting paid out to your spouse or your ex-spouse will also increase. Whereas if it's a flat rate, then the cost of living expenses or adjustment would stay with you and you'd reap those benefits as opposed to it going to your spouse or ex-spouse. So really, it needs to be discussed with an attorney because it is very case specific.
As I hinted at the beginning, it's a very difficult question. And we actually, as Asa pointed out, we have an appeals team. We also have a Quadro team, which is someone that helps with division of retirement accounts. In doing this, like I said, almost 21 years now, it is by far one of the most complicated issues because it is generally governed by federal statute, and it is highly negotiable. What that means is each and every retirement account has its own contract, which has different rules where we have to, be negotiating those terms, as Athena pointed out, and that we're going to try and do that to your benefit so you get to keep the most possible. But I think we have reached the end of our time today. I want to thank our panelists. You guys were fabulous. We had, I think, a lot of great discussion, a lot of great points for those 5 topics for guys that are facing divorce. And we want to remind everyone here that joined us, please visit us at CordellCordell.com or call us at 1-866-DADSLaw.com so you can get legal advice and get in contact with a Cordell attorney that's in your local area. Reminder, we do virtual consults, although most of the world is opening back up. We also are doing in-person consults, but happy to meet with you in a virtual setting as well to accommodate you. Reminder, usually Scott Trout hosts the Men's Divorce podcast. Please keep an eye out for those. And thanks for joining us today. Our live webinar today was presented by Lexicon, a legal technology and services company. And we are pleased to have you today. And thank you again to all the panelists and the viewers. Thanks.